What ended up happening is once a lot of these, this new material, these FBI documents started to get unsealed, we started to learn that there's more to the story. There's more, the basis for the investigation seems like it was manufactured a lot more than it was warranted. We have notes from a lot of these people. We have Lisa Page, we've got Peter Strzok, we've got Christopher Steele, we've got James Comey, we've got Carter Page, we've got Sidney Powell, who is representing Michael Flynn, we've got Eric Holder, we've got Sally Yates. Now we've got even evidence that Joe Biden and Barack Obama were having a conversation about this case in the Oval Office and sort of guiding the investigation even as they were leaving office. So basically, one president is sort of setting the framework to prosecute another president prior to him leaving office during a transition of power over a manufactured phone call or an allegation about a phone call, which was allegedly collusion, which to me doesn't sound anything at all like collusion other than it's part of the transition team having a natural conversation that they need to have. So this entire investigation comes to fruition and the FBI documents start to get unsealed. We have a lot of changing of the guards. The Trump administration ejects a bunch of people from the Obama era. They bring in new people and these documents get unsealed. And the Department of Justice then turns around and says, you know what? We're actually going to drop the charges. So May 7th happens and we're going to dismiss everything. We're just going to dump this case because we don't think we can prove it anymore. We don't think that beyond a reasonable doubt that we can prove that Michael Flynn did collude or that he did commit any of the crimes that were alleged. They don't even think that the investigation should have happened. It seems like it was a political investigation rather than a legitimate investigation. I just told you about General Michael Flynn and all of his accolades and all of his background. Turns out that he's more in alignment with those credentials than any of the other allegations. So these docs get unsealed. The Department of Justice turns around. They go to the court and they say, listen, we know we've been prosecuting this case for a long time, but we don't think we have the evidence anymore for it. And we're going to turn around and we're going to dismiss the case. Should be the end of it. Okay, remember back to your constitutional law class or your civics class or your social studies class. Remember what we're talking about. We're talking about 3 co-equal branches of government in the United States. You've got the executive, you've got the judicial branch, and you've got the legislative branch. We got 3 co-equal branches of government. Same type of thing happens in criminal law. We have 3 parties, right? We've got the judge. We've got the defendant, who's the defense. In this case, it was Michael Flynn. We've got the prosecutors, right? And they're all supposed to have 3, there's supposed to be 3 co-equal branches of government or 3 co-equal branches. The defendants have a certain number of rights. The prosecutor has a certain number of rights and the judge has a certain number of rights. And these things are all supposed to operate without kind of getting meshed into one another, right? If the prosecutor's office and the judge's office are colluding and conspiring with one another, it's really hard for the defendant to do anything. So the judge is supposed to be the neutral arbiter. The prosecutor is supposed to be the one who brings the charges, and the defense is the one who defends against those charges. So in Michael Flynn's case, yeah, they file a motion to dismiss. They want this case gone. The defendant wants his case gone. The prosecutor's office comes back and says, yeah, you know what? After a lot of investigation, we also want the case gone. We think it's nonsense. We don't think there's any basis for continued prosecution. So we've got 2 people agreeing in this courtroom saying this case has got to go. But what happens? The judge, who ordinarily in any other criminal case I've ever been a part of or our firm has been a part of, if the defense files a motion to dismiss or the government files a motion to dismiss and they're in agreement, if these 2 people are in agreement about what should happen in a case, the judge just basically says, sure, yep, you got it. Because that's what the judge is supposed to do. They're neutral. They're not supposed to take a side, especially when they're in agreement. If there's a disagreement, then the judge goes in and they ask questions and they hold hearings and they get to the bottom of it, right? And then the judge issues a ruling. So if you say, the defense says I want it dismissed, the prosecution says, no, we want it to stay, then we have arguments over that. But in Flynn's case, we had both sides who said, this case is nonsense. We want to dismiss all of these charges. And the judge said no. The judge said, nope, we are not going to do that. Which, in my mind, it was raising red flags all across the legal community because everybody was scratching their head going, what? what's his basis for doing that? What's his authority to not dismiss the case? So now what we're seeing is the judge was sort of acting almost as another prosecutor. The judge was saying, Mr. DOJ, Department of Justice, Mr. Government, we don't think that you are being forthcoming in your dismissal, and we're not going to let you dismiss the case. So we're going to act almost as the prosecutor, and we're going to say no dismissal, even though the defense and the prosecution were in total agreement for the dismissal of the charge.